session.
Please be seated, everyone. Good morning, everyone. Welcome to the April docket of the Kansas Court of Appeals, sitting here at the Johnson County Community College. We are very happy to be here. We come here once a year for hearings. This is always such a great venue for us, so we're excited to do our hearings today with some students watching us, and maybe we can all learn a little bit about how the appellate process works here in Kansas. My name is Tom Malone. To my right is Judge Steve Hill, and to my left is Judge Mike Boozer. We are the panel of judges for the hearings today. I will call the cases in the order of the published docket. When I call your case, the attorneys can come forward and have a seat up at council table. It's a little different than the normal court setting, so we'll try to accommodate the best we can. Please give us your name to make sure that we have your appearance correct, especially if your name is not on the brief. Let me remind you that on our court we have read your briefs, and so we're familiar with the facts of your case and what the issues are in your particular case. You might want to keep that in mind as you make your argument. As the presiding judge, I'll be the timekeeper. Each party is given 15 minutes for your argument unless it's designated differently on the docket. If there's more than one attorney per side, you should let us know in advance how you wish to divide your time. And the appellant attorney should let us know at the beginning of your argument if you wish to reserve any of your time for rebuttal. After we complete the hearings today, we will take your case under advisement. Your case will be deemed submitted for decision, and we will take the case under advisement and get a written decision out to you and your clients just as soon as we possibly can. So with that, I'll go ahead and call the first case on this morning's docket. It is a case from right here in Johnson County. It's 112-047. It's entitled In the Matter of the Marriage of Rose Medill Moore and Lyle Vincent Moore.
Rose Medill Moore, the appellant, appears by counsel Ronald W. Nelson and Ashlyn Yarnell. Ronald W. Nelson will be arguing the case.
All right, and we did receive a notice that the attorney for the appellee will not be joining us this morning. That's unusual. We usually have two sides for every argument, but that's not required, and so we'll just have a presentation from one side at this morning's hearing. And before we actually get into the argument, this is a little unusual, but I have written summaries of each case, and I'm just going to read a summary of this case for those of you in the audience so you know a little bit about what this case is about before we actually have the hearing. In this particular case, Rose Medill Moore and Lyle Vincent Moore divorced in 2001. As part of their divorce, they equally divided their pensions. Rose was a public school teacher, and her pension plan was with the Kansas Public Employees Retirement System, commonly known as CAPERS. Rose retired in 2010, and in 2012, Rose and Lyle agreed to enter a qualified domestic relations order, commonly referred to as a quadro, to divide the CAPERS pension. Rose had already received 26 months of Capers benefits, however, so Lyle filed a motion in the divorce case asking for half of the benefits Rose received before agreeing to the quadro. The district court granted Lyle's motion, and Rose appeals from that judgment. There's a couple of issues in this case. The first issue is, was the division of property a judgment subject to the dormancy statute? And a second issue is, since the division of, if the division of property was extinguished, did the district court have jurisdiction or authority to order the money judgment? So with that explanation, Mr. Nelson, go ahead and present your case. And I guess I won't ask you if you wish to reserve any time for rebuttal.
I will not, and
I don't think he was going to give you any anyway.
I probably wouldn't. May it please the court. Kansas law directs that a judgment expires and cannot be enforced if no action is taken to enforce that judgment within 7 years after entry, 5 years plus 2 additional years, essentially, of a grace period. The statute provides that this period may be extended, potentially indefinitely, if, number one, execution is made within the time, number two, the judgment is renewed within that time, or number three, the parties agree to revive it by written stipulation. As Chief Judge Malone has already indicated, these parties were divorced and a property division, including division of the retirement benefits, was made in 2001. There was no action taken on any matter regarding the retirement accounts other than myself sending to the federal government a copy of that decree asking that they respond back. Nothing was done with regard to the Capers retirement until 2011 when Rosemore, my client, filed a motion asking the district court to enter a court order acceptable for processing on the federal matter.
Now, Rose did not become eligible for her Capers retirement benefits until 2010, is that correct?
That is correct. She had already retired by the time we filed, around the time that we filed our motion for court order acceptable for processing on the federal portion.
But she wasn't eligible for retirement benefits until 2010, and this judgment to divide the pension couldn't have been enforced any earlier than that, could it have been?
Well, she was eligible for it. She didn't actually retire in 2010. So she didn't start receiving it until 2010. That's correct.
And you don't become eligible until you retire and start receiving the benefits, correct?
Correct.
All right.
In this case, the parties ended up agreeing, number one, to a form court order acceptable for processing on the federal portion, and it included its terms. And then on the Capers, even though there was no motion filed by Lyle, the parties entered into a qualified domestic relations order on that portion.
What's the practical effect of that?
The practical effect of it in our position is that the federal government and the order itself directed that any benefits paid after that date would be divided between the former husband and the former wife as set forth in that qualified domestic relations.
And that mirrored the original judgment of the court way back when.
It did.
Now, my question is more specific. Does that agreement qualify under 60-2404 that revives the judgment?
We believe that it does as a prospective portion.
From that point forward?
Correct.
But
Because of the language of that order.
But in this particular case, and that was all approved by the court.
That's correct.
In this particular case, she had received 10 or 12 months of payments before that, and he wants part of that.
That is correct.
And that's what you disagree with,
That's correct.
okay?
And it was not until a year after the parties entered into these agreed dual orders, dividing their prospective receipt of retirement benefits, that Lyle then, again, 1 year later, filed a motion asking the district court to enter a money judgment against Rose Medill Moore for the past amount that she had received. Now, it's significant that in Judge Foth's order, he makes reference, and everyone in this case made reference to the Marriage of Smith case, which is really the only Kansas case that deals with dormancy, expiration of judgments, and retirement benefits, qualified domestic relations orders. What Judge Foth said, however, was that, number one, the case was decided wrongly, but number two is that judgments were only money judgments, and that because the district court has the power in Kansas to divide marital property, and that because Kansas law says once a petition for divorce is filed, all property of both parties becomes marital property, there would be chaos if the court were not later able to enforce its orders.
Well, they can't acquire marital property after the divorce, can they?
They cannot.
Even though the district court might agree with the Smith decision, he had to comply with it, didn't he?
That is our position, that the judge had to comply with it or distinguish it, but what he did was said it's bad law.
He chose to ignore it.
He did, and perhaps more. Our position is Judge Foth seems to try to distinguish a judgment from a money judgment, but that's not recognized anywhere in Kansas law. KSA 6254 defines what is a judgment, and a judgment is a final determination of the rights of the parties on any particular matter. It is undisputed, and the appellee in their brief admits that this divorce and all property determinations and other orders included in it were final in 2001. The appellee doesn't seem to argue that in favor of Judge Foth's differentiation between a money judgment and a judgment. In fact, they say a judgment is a judgment.
When is a quadro typically filed? Is it at the time of the divorce, at the time the pensions become eligible, somewhere in between, or is there any statute or rule that covers this?
There is no statute or rule that covers it. Now, typical practice, best practice, if you will, is that as soon as the decree of divorce is entered, dividing the parties' property in the divorce, the qualified domestic relations order or whatever other order dividing the retirement plan is prepared at that time. So within a very short time after the divorce decree, property division is made.
In fact, Cricket Elrod recommends that in her handbook on
That is correct.
marital law, does it?
That is correct. And part of the problem is highlighted by the Smith case, which is a delay in doing so, in preparing that qualified domestic relations order, risks the judgment becoming dormant and then expired. And as the Smith case says, an expired judgment is extinguished, cannot be executed upon, again, unless the statutory reviver requirements are met. And our position is, first of all, the statutory requirements in this case were met by an agreement between the parties allowing the prospective division of the retirement plan, but there was nothing in that order that allowed the parties to go back or do anything other than a prospective division by Capers.
I guess my primary question is, your client did not retire and become eligible to receive her pension until 2010.
That is correct.
Any type of judgment, the dormancy period doesn't begin to run until the judgment can be enforced. And so if she didn't start collecting her retirement benefit until 2010, it seems to me that that's when the dormancy period starts to run, and how could it possibly have become dormant and expired by 2012?
Well, and the statute speaks to that. The dormancy begins on the date of the judgment, not on the date that a party may seek to enforce it.
But as long as enforcement of the judgment is stayed or prohibited, the dormancy period is not running.
That is correct. And in this case, enforcement was neither stayed nor prohibited.
Why? The husband couldn't have enforced this judgment until 2010 anyway.
The husband could have by sending in and obtaining approval by Capers of a domestic relations order, going through that process, getting it approved, and then waiting.
You know, I think what the chief is getting at here is that we do have this case, Bank 4 Wichita versus Plain, which says with regard to that tolling provision in judgments, that subsection C codified prior case law, which provided time would not run on judgments impossible to collect. And if they had, if the quadro had been filed the day after that divorce, you still ain't going to collect any retirement benefits until that person actually retires. So it would be impossible to collect on that judgment until Capers says, congratulations, you're retired, here's your bag of money.
Well, in a way, yes. The court could have determined, or the parties could have agreed that it would be valued and divided at that time. Instead, they chose to stretch it out and say, when either party retires, then that's when your payments come into effect.
And you know, on the Smith case, correct me if I'm wrong, but as I recall on that case, we were dealing with a $140,000 IRA that the settlement agreement in the divorce agreed that they were going to split. But that was money extant. That was, the bag of money was there at the time of the divorce, and they waited 10 years to do anything to try to collect it at that point, which seems to me very different than this situation where you don't have that bag of money's there. That bag of money's 10 years in the future, which would seem to make more sense as far as this notion of tolling of the dormancy, meaning that the judgment would still be collectible 12 years after or whenever.
One of the additional things is that, as noted in the Smith case, there is virtually no law across the country with regard to this issue. Although the issue of reserved jurisdiction or deferred jurisdiction is referred to in many cases, is referred to in many law review and other articles, there is nothing that really talks about reserved jurisdiction with regard to dormancy statutes.
There's nothing in Kansas that allows the court to reserve jurisdiction on this.
There is not. There is
No statute or case precedent, is there?
That is correct. The cases that do talk about reserved jurisdiction in Kansas have to do with maintenance and the reserved jurisdiction of the court to modify or change the maintenance obligation.
But that's done by statute.
That is done by statute.
Here, the judgment is quite simple. You get half of the retirement benefits. That's it.
That's correct.
And that was done in 2001.
Correct.
Didn't do anything about it, didn't issue the quadro until 2011, 12,
2012.
by consent.
Yes.
The judgment was never changed.
That's correct.
And with the passage of time, that judgment was extinguished, but only a portion of it was revived by consent.
That's correct.
That's your position. All right, thank you.
I have nothing further unless there are more questions from the court.
Thank you, counsel. We appreciate your briefs and your argument. We will move into the second case on this morning's docket. It is also from right here in Johnson County. This is a criminal case. It's number 110562. It's entitled "The State of Kansas versus Christopher Dale." And again, I'll go ahead and read a brief summary of the facts of this case and what the issues are for the benefit of students that are here or watching this presentation. The facts are as follows, briefly. After receiving a phone call from his girlfriend's cousin, Drake Rickerson, saying that Drake was being picked on by other boys at a nearby skate park, Christopher Dale, our defendant here, took a BB gun and went to the skate park. Once there, Dale threatened the other boys with the BB gun and hit one of them with the BB gun. When Dale and Rickerson ran away, the boys' cell phones and an iPod, which had been on the ground near them, turned up missing. Police later recovered the stolen items at an apartment where Rickerson and Dale were staying. Based in part on the testimony from Rickerson, a jury convicted Dale of 2 counts of aggravated robbery and 1 count of theft. Some of the issues being argued in this case: one issue is, did the district court commit reversible error by erroneously instructing the jury on the definition of aggravated robbery? A second issue, did the district court err by refusing to give Mr. Dale's requested jury instruction on general criminal intent and ignorance or mistake of fact? Third issue, did comments made by the prosecutor during closing argument constitute prosecutorial misconduct that denied Dale a fair trial? There's also a couple of issues in addition to that, but those are the main ones. Our counsel here today are regular players here on the Court of Appeals. We have Mr. Rick Kittle representing the defendant, Mr. Sean Minahan representing the state of Kansas. Mr. Kittle, whenever you're ready.
Good morning, Your Honor. I'd like to reserve 3 minutes for rebuttal, if I could, please.
Okay.
I'm not going to have time to touch on all the issues that are raised here, so I'd like to focus on the first 2 in the yellow brief.
Well, since it's electronic, it's wired with a yellow stripe.
Okay. The brief with the yellow stripe, Your Honor.
All right.
The first issue deals with an instruction that was given by the court for the definition of aggravated robbery. And the first element of that instruction, actually there were 2 instructions, one for each count of aggravated robbery. The first element of that instruction informed the jury that it could find Mr. Dale guilty if, quote, the defendant and or his accomplice intentionally took property, unquote, from the alleged victim.
Can I stop you right there, Mr. Kittle? Have you ever seen a criminal complaint written in such a fashion before? And or?
No. And
I mean, the question that immediately comes to mind is, what do you have to do to commit this crime? And or, who did it? The man charged or somebody else? Why? Well, I guess you can't answer that, but tell me the effect that has on you, on your client.
well, first of all, defense counsel proposed instructions, which were the standard instruction for aggravated robbery, saying that in order to find Mr. Dale guilty, it had to find that the defendant intentionally took property. The jury, during deliberation here, asked a question which I think shed some light on your comments, Your Honor. The question asked by the jury during deliberation was, please give clarification on element 1, and or. Does this mean either defendant, accomplice, or both? And that's the crux of the problem here. The instruction, and the response to the instruction by the court basically said and or means and or, and I can't explain it any further than I've already stated in the instruction. The problem here is that that instruction would allow the jury to find Mr. Dale guilty even if it was convinced beyond a reasonable doubt that he had no intent to take property.
Now, I understand that the jury was also instructed on the law of aiding and abetting.
That's true.
And could he have been found guilty as an aider and abetter?
My response to that, Your Honor, is even under the aiding and abetting instruction, the person has to, quote, intentionally aid and abet someone else. So even under that statute, the defendant has to act with a particular intent in this case. That, I think that aiding and abetting instruction is completely undone or undermined by the instruction that was given by the court stating the elements of aggravated robbery. And again, I think that's evinced by the fact that the jury asked a question about that. The and or instruction completely eliminated the need for the jury to find that Mr. Dale intended to take property.
I'm asking this question mainly for the benefit of the students in the audience, but your client's entire defense here is that Rickerson picked up the iPod and the cell phones and ran off with them, and your client had no knowledge of that.
That's correct. The theory of defense here was based upon evidence indicating that my client, Mr. Dale, didn't even see these items at the time of the alleged offense, didn't pick them up, and wasn't aware of their existence until long after the fact when they were actually found by the police officers. Ultimately, when you come down to a standard of review in this case and how that's applied here, I would argue that the state here cannot prove beyond reasonable doubt that the error in that instruction did not affect the outcome in light of the entire record. Because given the instruction, given the fact that the court failed to further explain what it meant or explain away what we believe is the inherent error in that and or language, he could be found guilty based solely upon the intent of another person without having any intent on his own to commit this crime.
Just by being there?
Just by being there. So, again, the error was reinforced by the court's response to the question asked by the jury. That had the effect of totally undermining the theory of defense in this case, because the theory of defense here was based upon intent, and the instructions say intent doesn't matter. You can find Mr. Dale guilty without having any intent at all.
What was the best evidence that you had to support this defense, that your client was just there with a gun and all these bad things were happening and he had no intent to participate in it?
Well, there was evidence produced at trial. I think that after the fact, Rickerson wanted to sell these phones to someone, but he didn't want to let Mr. Dale know that they had been stolen, because if Mr. Dale knew that, Mr. Dale wouldn't buy stolen property. So that's evidence coming from the accomplice himself that Mr. Dale didn't realize that these items had even been taken. If I may move to the second issue, which is also an instructional issue. At the top of page 15 of the appellant's brief, there are two PIC instructions that were requested by defense counsel, but the court refused to give them. And the court's reasoning here, I really don't understand why what this reasoning has to do with the instructions that were requested, but the court refused to give these two instructions, one providing a definition for intentional conduct and one talking about ignorance of a fact being a defense in a case. The court rejected them, saying that it didn't believe that the lesser included offense instruction was justified in this case, and therefore the instructions wouldn't be given. But I'm not sure what that actually has to do with the purpose for which these instructions were requested. The first of the instructions, which is PIC 54.01A, provides a definition for intentional conduct.
Let's pick third.
Right. And this was at a time, this was back before the revamping of the Kansas Criminal Code and before we have this new PIC 4th.
I was going to say, we're now in the land of other mental states.
Right. And this was at a time when there was a general intent, a panoply of general intent crimes and also a list of specific intent crimes. This instruction is 54.01A. The controlling law at the time said that this instruction is to be used only where there's a general intent crime and where the state of mind of the defendant is substantially at issue in the case. We would argue that both of those are true in this case. I've cited in the brief the case of State versus Escher, which is a case of this court, which has lists of general and specific intent crimes and refers to aggravated robbery as a general intent crime.
How about the theft, though? That was a specific intent crime, and he was also charged with that.
That's true, but if that's the case, then the court didn't make any distinction, or should have made some distinction to allow for the giving of this instruction.
Was the court asked to make a distinction?
I don't believe so. The court was asked to give this instruction, though, and
But it would have been error for the court to have given that as a flat instruction, given that you have one crime, aggravated robbery, which is a general intent crime, and theft, which is a specific intent.
I would have to go back to the record to see whether, in the process of the dialogue between court and counsel on this instruction, whether defense counsel made it clear that this is to be given for the purpose of the aggravated robbery.
I didn't see it,
Okay,
but
well, it may not be in there, Your Honors. I just don't recall off the top of my head. Nevertheless, I would argue that this instruction is needed in this case because, and the other thing is, before I forget, Mr. Dale's state of mind was substantially at issue in this case because his theory of defense was, did he have intent? Did he have knowledge that these items that were taken? The Kansas Supreme Court has said in a case called State versus Cheeks that it's not reversible error to refuse to give this instruction, even if requested, as long as the substance of the instruction is present in other instructions that were given to the jury. I would submit that that's not the case here, that there aren't any other instructions that were given to the jury that told the jury that intentional means willful and purposeful and not accidental. You don't find that in any of the other instructions that were given by the court. And given the crucial nature of intent in this case and the theory of defense and the need to specifically define intentional conduct for the jury, particularly in light of the question asked by the jury and the court's saying and or, meant and or, under those circumstances it was particularly important that the court give this instruction so the jury would fully know what intentional conduct meant in this case. The other requested instruction, I'm not sure how much time I have, Your Honor, but...
You have 1 minute until you're into your rebuttal.
Thank you. 5403 is an instruction that informs the jury that it's a defense if by ignorance or mistake of fact the defendant did not have at the time of the crime the mental state or the specific intent needed, or the intent needed to, as required as an element of the crime. Now, this instruction is not given where the ignorance of a fact is the ignorance of something like the age of a minor or that a statute exists, but that's not the case here. The fact of which Mr. Dale was ignorant was the existence of those phones. If he is ignorant of the existence of those phones at the time of the crime, that tends to operate as a defense for him, because if he wasn't aware of the presence of the phone, he couldn't have had any intent to take them.
How can you steal something that you don't know isn't there?
Exactly.
Isn't that instruction, though, just for a specific intent crime?
Well, I don't think so. I mean, I think
Maybe I'm wrong.
I don't think so. I think it's fair game in this situation.
Well, theft is a specific intent crime, isn't it?
Theft is.
Theft, that, again, we have...
Right. You have these two
Right.
crimes, and one is under the old law general intent, two are a general intent, one is a specific intent crime. But in this case, Mr. Dale's lack of knowledge of the presence of the items that were stolen tends to exonerate him. It tends to negate a state of mind that is necessary for conviction of these crimes. And I would argue it tends to exonerate him whether it's a general intent crime or a specific intent crime under the facts of this case. And so, again, the standard of review here, because this was a requested instruction, this court has to view the evidence in the light most favorable to Mr. Dale. If that's done, I would contend that it was error to refuse to give the requested instructions, and I believe that would constitute reversible error in this case. I would submit the other issues on the brief for the court's consideration.
May it please the court, Sean Minahan, Assistant District Attorney with the Johnson County District Attorney's Office for the state. The defendant has raised 5 different issues. I'll stick to the 2 issues that were addressed by the appellant.
I'm glad you're here, Mr. Minahan, because
Are you?
I am, because I want to ask, when I first got this brief and I saw how this was charged, I don't think, I've read a lot of criminal complaints over the years. This is the first one that I've ever seen somebody charged and/or the accomplice. What possessed you to charge the man in such a fashion? It seems like to me, you aren't alleging that he did anything other than to be there.
Well-
And either he did it or the other guy, but he's guilty because he's with the other guy. Is that what you're saying here?
Well, first of all, I didn't personally charge it. I don't want anybody thinking I. Second,
Very courageous stand.
thank you. Thank you. You know, I didn't throw out a prosecutor's name that charged it. I think that they all knew that the defendant wasn't the one that physically took the items from the individuals. It was his co-defendant. And that the defendant was guilty of this crime on an aiding and abetting.
You know, I've seen complaints coming out of the Johnson County District Court for years that charged successfully aiding and abetting. It can be done, but you didn't
Right.
do it here.
Well, and the case law says that you don't have to charge aiding and abetting, that you charge the in fact, when you're convicted of aiding and abetting, you're really convicted of the underlying crime. So
But the difficulty that you have here is when it comes to the defense. When you've got a defendant raising when it's a charge like it was here, when you got a defendant raising I didn't know it was there. Well, you know, how does that work then, and if he's being charged as a principal, not as an aider and abetter?
Right. Well, I think if you look at the evidence, it becomes clear. The jury instruction states that either the defendant and/or his co-defendant intentionally took the property from them. Well, the evidence presented in this case only established that Rickerson took the property from the individuals. The question then becomes, so there's not going to be any dispute over the and/or, I don't think, based upon that.
I just want clarification in my own mind. The and/or was in the charging document? Because I know it was in the instructions, but are we sure it was in the charging
I'm
document?
not sure that
All right.
Judge Hill, I think,
I think it is, but
I'm not sure.
if it's not, I stand corrected.
Um,
It's not in the pick instruction.
No. I think what's really odd about it is that they were charging him as an aider and abetter. And then how do you say that the defendant took this property? You know, they probably should have cleaned it up and said that the co-defendant took this property and that this was an aiding and abetting. But having said that, the evidence really establishes that Rickerson took the property. The question then becomes, either Dale thought that he was there to fight them because they were picking on Rickerson, or Dale thought that they were there to steal the property from them.
And that's the crux of it, because it's an aggravated robbery, you gotta take property.
Right. And so the aiding and abetting instruction specifically states, a person who, either before or during its commission, intentionally aids, abets, advises, hires, counsels, or procures another to commit a crime with intent to promote or assist in its commission is criminally responsible for the crime committed regardless of the extent of the defendant's participation, if any, in the actual commission of the crime. So the aiding and abetting instruction actually requires Dale to have the intent to commit the crime of robbery. Without that intent, they couldn't have convicted him.
And what was the best evidence that you had to prove that he intentionally, this defendant, intentionally aided and abetted, helped the other individual to steal the cell phones?
Well, we know that the defendant held the gun, went over, and participated in the act, giving rise to it, right? Rickerson's testimony, Rickerson testified that they had a plan to steal.
And Rickerson was the principal.
Well, yeah, right.
And he got a deal to testify
Right.
against the aider and abetter.
Right. Dale brought a handgun along. They secluded the vehicle before they walked into the park. Based upon the number of items that were taken, it would have been hard for Dale not to have seen that they were stolen. They also ran back to the same car, drove back to the same house.
With the cell phones in possession?
Yes, cell phones and I think an iPod. The victims heard one of the co-defendants say, "You just got jacked." You know, the Rickerson told one of the victims, "Give me your stuff." All of this happened when Dale was around. So there's a lot of evidence to establish that Dale intended to take the property of these individuals. The second issue, general intent and absence of mistake or accident. General intent I find really interesting because I don't think it's that helpful. Intentional is a pretty commonly used word in America, in the English language. I mean, people know that intentional means not accidental. And so I don't know how helpful the general intent instruction would have been to tell them that this crime occurred willfully, purposely, and not on accident. I mean, that's commonly understood, I think. The question is, then, does that not instruct, and does that not explain to the jury that that the defendant's intent was at issue? I don't think that's right. I don't think that the defendant's argument is one of an accident or a mistake of fact or a mistake of a law, or a mistake of fact or an accident. It seems to me that his theory of defense is that they didn't have a meeting of the minds. And that's a lot different than the person that grabs a pair of pants on the floor. Of course, that's like the kind of the typical mistake of fact or accident. The defendant grabs a pair of pants on the floor of his apartment, puts them on, and then lo and behold, there's drugs in it. And he's like, well, I thought I put my own pants on. I put my roommate's pants on. That's kind of the classic. Well, that's a mistake. That's an accident that he grabbed the wrong pants. But here they're arguing that they didn't have the same state of mind. They didn't have a meeting of the minds, to use kind of civil jargon. And so I don't really think this is a mistake of fact or an accident issue. Finally, Finally, the mistake or accident instruction is only applicable to specific intent crimes. And so I don't even think that they could have given that. So unless this court has any. Oh, thank you.
One of the things Mr. Minahan said, that he didn't believe there was any dispute about the and/or language. But I don't think that's correct. I think the fact that the jury asked a question directly about that refutes that argument. With respect to the second issue.
How did the judge answer that question, by the way? I've forgotten.
He just simply said and/or means and/or. It's in common parlance, and he didn't think he could explain it any further than it was already. With regard to the second issue regarding the instruction defining intentional conduct, Mr. Minahan argued that wouldn't be helpful to the defense. But I think it would have been very helpful to the defense in this case, particularly where the court instructed the jury in another instruction that the defendant could be found guilty without having any intent at all to commit this crime. Under those circumstances, it was vital that the jury be informed of the definition of intentional conduct. And then finally, with respect to the second jury instruction, 5403, Mr. Minahan conveniently leaves out part of the language of that instruction. It's not just mistake of fact, it's ignorance of a fact. And that's the theory here. Ignorance of a fact of the existence of those cell phones and that iPod, the items that were taken. If Mr. Dale was not aware of the presence of those items, he could not have had any intent to take them. And so that's why that instruction is crucial. It's not mistake of fact, it's ignorance of a fact. And on those bases, I believe that the result of this case should be a reversal of the convictions, particularly convictions of aggravated robbery.
Did Dale testify in this case? He didn't, did he?
No.
So it was just through the presentation of argument, or through the presentation of the state's case and argument that the defense was laid that my client didn't know that a robbery was going down.
Right. Now, there were statements made, that he made to police. And
what, on those statements, help me out.
well, those statements basically support his theory of defense. He didn't know until after the fact that anything had been taken.
Okay, so that was before the jury.
Actually, you said something that popped a question into my mind. If your arguments prevail here, do they just affect the convictions for the aggravated robbery, or what about the theft?
I don't think so. I think they apply to all of them because I think in a certain context they can be applied to all of them. If you're, we're talking about aiding and abetting theory here, which deals with the concept of intent. We have what I believe to be a faulty instruction on the aggravated robberies regarding the element of intent. We have the refusal of the court to give a definition of intent, and I think that applies to both the theft and the aggravated robbery conviction.
Okay.
Thank you.
All right, counsel, thank you very much for your briefs and your arguments. Moving right along, the next case is from Leavenworth County. It is, again, a criminal case. It's number 111902, entitled The State of Kansas versus Johnny Davis. Just a very brief summary of the facts of this case and the issues. The facts are as follows, briefly. After a law enforcement officer pulled over the car Johnny Davis was driving, Davis ended up charged with 2 crimes. In the portion of the charging document related to a weapons violation, the document contained the word attempt. At the beginning of the trial, the district court instructed the jury that a mistrial is an expense and inconvenience to the parties, the court, and the taxpayers. During the trial, a law enforcement officer testified that after running Davis's information, he learned that Davis was driving with a suspended license. Davis testified he was aware of the suspension, and acknowledged that he had never paid a reinstatement fee, but he believed his license had been reinstated due to a letter he received from the Kansas Department of Revenue. The jury ultimately convicted Davis of the aggravated weapons violation and also for the driving on a suspended license. Some of the issues raised in this case: number one, did the district court lack subject matter jurisdiction over the crime of conviction, specifically the weapons violation? Number two, did the district court err by giving improper preliminary jury instruction? Number three, did the district court err by finding there was sufficient evidence for the jury to convict Davis of driving on a suspended license? And then there's a fourth issue: did the district court err by classifying Davis's pre-1993 in-state convictions as person felonies for criminal history purposes in order to determine what Mr. Davis's sentence should be? So with that explanation of the case, we again have Mr. Rick Kittle representing the defendant in the case. And who do we have here for the state of Kansas?
May it please the court, Your Honor, this state appears by Christopher Scott, Assistant County Attorney with Livermore County.
All right, thank you. Mr. Kittle, do you wish to reserve rebuttal time?
3 minutes, please, Your Honor. The state, in this case, I think ostensibly wanted to charge Mr. Davis with carrying a concealed weapon as a convicted felon. But if you read the count of the complaint charging that, you read it closely, you'll see that in the middle of that count, the words "attempted to" are included in the charging document. Kansas statutory law indicates that a district court has jurisdiction over the crime charged and any lesser included offenses of the crime charged. Our argument here today is that what was charged in this charging document was attempted carrying a concealed weapon. So in this case, the district court would have had jurisdiction over that crime, the attempt, the anticipatory crime, but it did not have jurisdiction over the crime for which the court ultimately entered a judgment of conviction, the completed crime.
Mr. Kittle, let me stop you there if I could. I've got a copy of the, that you cite in front of me. To it, criminal threat in violation of KSA 213419, subsection A1 from Leavenworth County District Court case 2009 CR 592, comma, then and there being present did unlawfully and knowingly attempt to, semicolon, carry concealed on his/her person a dangerous or deadly weapon, to it a dangerous knife, and cites another statute. And it charges this as a severity level 9 non-person felony. Correct?
That's all correct.
Is not an attempt would be a severity level 10 person felony, would it not?
It would be.
And if he had been charged with an attempt, there would be a citation to the attempt statute, correct?
Perhaps.
But there was none here.
There was not.
That would be 215301A. And there would be language usually, commit an overt act towards the perpetration of the crime of.
That's an element of the attempt.
That is an element of attempt. You argue that the inclusion of this attempt semicolon means that he is now charged with an attempt.
Yes.
Insertion of one word makes it an attempt charge.
In this case, yes, because the words "attempt to" change the complete nature of this.
It doesn't say attempt to semicolon, whatever that means. The punctuation mark, I think, gives me pause in understanding your argument. I guess basically your argument is you can't be charged with one thing and convicted of another.
Yes, that's true.
And
That's
so-
true. That's true. That's my argument, and that's true under the law.
All right.
Were you finished, Judge Hill?
Yes, go ahead.
But By challenging the language or adequacy of the charging document,
I'm not doing that, though.
well, that's what it seems like that's what.
I am not.
I know that's not what you want to do, but aren't you essentially bringing a motion to arrest judgment for the first time on appeal?
No.
Why aren't you trying to do that?
Because we have never claimed anywhere in our brief that this is a defective complaint. We have said if it charges anything, it charges attempt. And the district court would have had jurisdiction over attempt, but it didn't have jurisdiction over the greater crime of the completed crime that for which there was a judgment of conviction.
I know you don't want to get into this whole post-Hall standard, but isn't that the way courts normally analyze this type of issue?
No. Obviously, I've read the state's brief here, and they talk about notice provisions and that he should have objected to this statute. But I'm arguing there's nothing to object here. This is not a defective complaint. A notice argument is typically something that's argued when we are complaining that the language of the charging document didn't give him adequate notice under the Constitution of the nature and the cause of the action against him. Judge Hill, you mentioned the fact that this has some statutory numbers in it. But if you look at, I believe the statute is 223201. That talks about complaints. And it says the complaint must set forth the facts constituting the crime charged. So I would argue it doesn't make any difference what statute numbers are in there. What's important in the complaint is actual facts that are alleged. And the facts that are alleged here can only be construed reasonably is not that he completed the crime, but that he attempted to do this crime.
Matter of fact, it's critical to your argument that this is a rock-solid complaint. Nothing wrong with this. Your client was charged with attempted possession of a weapon.
I don't necessarily see it that way.
Well, your argument, not to play Justice Scalia here, but what your best argument is that if that charge is attempted possession rather than possession, the court only gets jurisdiction over a charge that is stated in the complaint. This court had jurisdiction to find out whether or not this fellow was guilty or not guilty of attempted possession. Nothing more, nothing less.
That's correct.
Good argument.
Thank you. And, counsel, I guess will have an opportunity to explain why the words attempted to are included in this charging document when they're not in the statute.
We'll ask.
The other point is there are crimes, and I think DUI is an example, where the definition, the statutory definition of DUI says that driving under the influence is operating or attempting to operate a vehicle while under the influence of alcohol. So the statute in that situation makes the attempt the actual completed crime. But you're not going to find the words attempted to in this statute defining carrying a concealed weapon. So adding that language, which is an element of a crime, fundamentally changes the nature of what's being alleged in this charging document.
So did any of this come up before the trial court?
No.
So why should we even consider any of it now?
Because it's a jurisdictional matter. And in a judgment of conviction entered without jurisdiction is void. And it's not your typical complaint that the complaint is defective and therefore the district court didn't have jurisdiction. There's nothing wrong with the complaint. It's just that it charges a crime that the defendant was not convicted of and which the court didn't have jurisdiction over.
I take it in the jury instruction on the elements, the word attempt did not appear.
That's true.
It wouldn't be a completely adequate charging document for an attempt, though, right?
It wouldn't, but it's not an adequate charging document to charge the completed crime either. And that's what he was found guilty of. That's what he was found guilty of. That's the judgment of conviction in this case. If I have time, I'll touch on the second issue. That deals with the the introductory instruction that was given by the court. And the main point I want to make here is there was no objection to that instruction, and typically that would mean clear error standard of review. What I'm arguing is if you look at the statute that provides for that clear error standard, it seems to be talking about instructions that are given at the close of evidence. It also says that an opportunity must be given to counsel to object to instructions outside the presence of the jury. But that's not the case we have here. This is just an introductory instruction that was given by the court after the jury was sworn, but before the taking of evidence. There wasn't any colloquy between court and counsel as to the propriety of any of these instructions. The court just gave the instructions. It's manifold errors in that language telling the jury that a mistrial is an inconvenience and an expense to the court, the parties, and the taxpayers. And in fact, there's an old Kansas Supreme Court case, which is called Neely versus Travelers Insurance, that says that an instruction which appeals to the jurors' interest as taxpayers is reversible error. That's what I'm arguing the result should be in this case. Clear error should not apply here. This is plain error. This introduces matters that the jury should not be considering in reaching a verdict. It tends to undermine the importance of the defendant's exercise of his right to a trial. There are multiple errors associated with this, and I think the most important, an important factor is that language is no longer in the introductory instruction. And I think that's a tacit acknowledgement that that language is erroneous.
Well, that was in direct response to the Supreme Court's ruling on this particular point, wasn't it? That was removed from the PIC instructions?
Yes, yeah, I believe that's correct.
Now, even in that Supreme Court case, they say it's error, but then they examined it, and under the facts of that particular case, it was harmless error. And they didn't reverse based upon that. So do we use a harmless error analysis here because of this language? I mean, if assuming we consider the matter without an objection.
I don't recall in that case that the argument was made that I'm making that clear error standard should not apply because this is before.
So you've got a different standard of a review
Right.
than what they considered.
That's correct.
So we would have to find beyond a reasonable doubt that the error wouldn't.
Well, to be honest with you, I'm not sure what the standard is. I don't believe it's clear error, but I'm relying upon this Kansas Supreme Court case, and Judge Elliott would say it's hoary with age. It's from 1935, I believe. But it still indicates that appealing to the jurors' interest as taxpayers is reversible error. Unless the court has other questions, I'd submit the other issues on the brief. Thank you.
And again, I'm Chris Scott. I'm an assistant county attorney with the Leavenworth County Attorney's Office.
You know what we're going to ask, don't you, Mr. Scott?
I believe so.
Why did you put attempt in that? Did you charge this man with an attempted concealed weapon, or did you charge him with carrying a concealed weapon? And why did you use attempt? Why did you do that?
Judge, he was charged in this case where the intention was to be charged with a completed act of an aggravated weapons violation by a convicted felon in the state of Kansas. I wish I had a great explanation for you on the word attempt. I think hindsight is 20/20 in here. If we did this complaint over again, we would eliminate the word attempt. I'm not sure why the word attempt is in there, but that is remedied by the charging document is to put the defendant on notice what he's charged with. And it is clear by the statutory language, which I'd argue is the most important factor to the complaint. What statute are you being charged with? He is charged with the completed act of aggravated weapons violation, and that is also shown by the level of offense being a level 9 non-person felony. As you stated earlier, Judge, it would be a level 10 non-person felony if he was charged with an attempt, as well as include the statutory language for an attempt, which I believe is 215301. Not only that, Your Honor, but the appellant was put on notice multiple occasions throughout the process at the trial court level of what he was charged with.
But the charging document is what gives the court jurisdiction to act upon the defendant. It's pretty important.
It is very
No
important.
matter how you look at it.
It is important,
And you got right there, smack dab in the middle of it, attempt to. Man, what does that language mean?
But as you stated as well, that there is no language in the complaint of an overt act was committed or that the crime was not completed. It says attempt, semicolon, and then goes into the language for a completed act. And the court did have jurisdiction over that completed act by the statutory language, and I'd argue by the language of the entire complaint.
Should the defendant have filed a motion for arrest of judgment?
I believe he should have, or at least if he had issues with it in this case, with confusion to it, what he was charged with any type of issues to what count was being or what charge was being given to the jury. As I was about to say, we had several instances throughout the proceedings, not just at the jury trial, but the defendant was explained by himself and with counsel what he was charged with in this case.
Of course, at the same token, you had the opportunity to file an amended complaint, did you not?
I could have filed an amended complaint before the preliminary hearing. I could have filed an amended complaint after the preliminary hearing. We could have asked the judge for an amendment before it went to the jury. But, Your Honor, it was never felt at any time that there was any issue with the complaint or what the defendant was charged with or whether there was a jurisdictional issue with the court.
Did this court have jurisdiction?
This court did have jurisdiction, Your Honor.
What about the second argument that Mr. Criddle brings up? I have read through the PIC instructions from time to time, and that language concerning, evidently, is this a common practice in Leavenworth County where the judge gives preliminary instructions and counsel aren't given a chance to look at them and object to them or consider them before they're being given? It's just automatically done?
Judge, and if you're asking, I guess, does the judge let us know ahead of time that he's going to read the instructions? Is that what
Correct.
you're asking? I would say no, Your Honor. I would say that it is a common practice. That particular instruction, at least in every jury trial I have had in Leavenworth County, I've been in Leavenworth County since January of 2013, that particular instruction is read before the presentation of evidence in each jury trial.
That portion concerning the heavy burden to the taxpayers is certainly not language that's found in the PIC book, is it? In fact, that language has been condemned by the Supreme Court, has been found to be error. This is error here, is it not?
Well, there are multiple cases, not several cases, to where courts did find error or at least express concern with that.
Well, is it or is it not error?
I don't believe it's an error, Judge, in this case for the court to read an instruction as suggested by PIC 50.010.
Are you asking us now to overturn the Supreme Court? Because I don't think we're going to.
I am not asking you to overturn the Supreme Court, Your Honor.
When they say it's error, I think we're probably duty-bound to say it's error.
I'd agree with that, Your Honor. I would state, though, this needs to be taken in the context of how it was read.
Well, yes, it is being taken into context because you're reading it to a jury. You're telling them, don't have a mistrial because it's expensive to do it. And none of that has anything to do with the guilt or innocence of the defendant, is it?
It does not.
And should not be. It just leads extraneous material. That's what the Supreme Court said in their opinion. And you're giving this instruction in every case?
It is given in, I can't speak for other attorneys, and I'm not sitting through their jury trials. I can tell you that this was not the first time this type of instruction was read in my particular jury trials.
Well, but the instruction you referred to, PIC 50.010, this language that is at issue in this case, that's not even in that verbatim PIC instruction, correct?
That is correct. I'm saying it was read in the context of, and you guys are aware of the instruction, it was read in the context of social media. It's in the PIC instruction
Right.
notes. Social media, internet, jurors in 2015 or in the last few years or in any recent case have an unlimited amount of access to information that if you get access to information ahead of time, that this can cause a mistrial in the case to which the court ties it back to taxpayer burden.
Well, but that's, the actual instruction says a mistrial just means the case has to be tried again.
That's correct.
It doesn't have this language of mistrial is an expense and inconvenience to the parties, the court, and the taxpayers. That's not in PIC,
That's
right?
correct.
Channeling Justice Scalia again, isn't your best argument that although it was error, because it was given at the front end of the trial to all the jurors, then we had the opening arguments, we had all the evidence, we had closing arguments, then we had the jury instructions, and in most, if not all, except one case where the courts have had a problem with that instruction is when jurors are deliberating in the trial, and they've been deliberating for a long time, and they come back and they tell the court, we can't decide, we're stuck, what do we do? And the court gives them the so-called dynamite instruction, which we have now disproven and disapproved of, which says, another trial could cost money, these people have worked hard to present this evidence, you need to get back there and make a decision. And we've said that's totally wrong in that context. That's a very different context than you're presenting.
It is a different context. This was an unwritten instruction. This was an oral instruction to the jurors before the presentation of evidence.
It's still coming from the trial judge to the jury. It's important.
It is important.
Every word that trial judge says to the jury is important. That's why we have records.
It is, but there is also an instruction that is given in written form to the jury instruction 11, which specifically states that you are to only consider the evidence in this case. And even if the court does find error in this case, it is not reversible error. The evidence in this case was overwhelming as to the counts charged. And a rational fact finder not only could, 12 rational fact finders did convict the appellant as charged in this matter. I have nothing further unless there are questions on the additional issues in this matter.
Apparently not. Thank you.
With respect to the second issue, and particularly Judge Buzzi, your question or comment referencing Judge Scalia, I think it's important to consider the sequence of events here. First of all, it doesn't make any difference whether the instruction is given prior to the taking of evidence or after the taking of evidence. It's still coming from the judge. It's still binding on the jury. And what happened in this case is the court, or the jury, took an oath that it's going to follow the law. And then immediately after that, the court gives this introductory instruction, which is the law, telling it to, essentially telling it in its jury deliberations and reaching a verdict, you can consider the fact that a mistrial is an inconvenience to the parties and the taxpayers and the court. That's going to have an effect on the minds of the jury because that's the law that they're receiving immediately after they receive the oath telling them that they have to follow the law.
So it's not the written instructions 2 days into the trial that they receive from the judge when he says, now here, these are the instructions you're supposed to follow in rendering a verdict. They're going to go back 2 days to the comment that everybody's first in the courtroom about this and that, and they're going to think, you know what, the main thing I got to think about is I can't have a mistrial. We've got to have a unanimous verdict in this case.
Well, yeah, I think those are just as important as what comes afterwards. And I think I cited to a Castorino case in the brief indicating that it's the oral instructions that are binding rather than the piece of paper that goes with the jury back into the deliberation room.
Well, they also got it orally along with the written instructions.
They did.
At the end of the trial.
But
Was there any indication of any mistrial at any point in this case? Was there any suggestion?
No.
Was there questions by the jury? Did they indicate to the court that they were having difficulty arriving at a verdict?
No.
Anything like that?
But the instruction at issue here is going to have a coercive effect on the jury that's not necessarily going to be revealed by something that happened on the record at trial. Close my comments.
Thank you.
Thank you.
Thank you, counsel, for your briefs and your arguments. We will move right along to the final case on this morning's docket. This case is from Johnson County. It's number 112006. It's entitled "In the Matter of the Marriage of Lynn B. Threet, formerly known as Hollandquest, and Lamont B. Hollandquest." Hope I pronounced all those names correctly. This case, quite frankly, is very similar to the first case that we had on this morning's docket. This is another post-divorce case involving the division of property, specifically pensions of the parties. Let me just read to you a very brief summary of the facts of this case. Lynn B. Threet and Lamont B. Hollandquest were married in 1996. At that time, Hollandquest played in the National Football League. As a player, he participated in the NFL pension system. Threet and Hollandquest divorced in 2005 after Hollandquest's career had ended, and the parties agreed to divide his NFL pension benefits as part of the divorce. In 2013, Hollandquest began receiving disability benefits under the NFL pension plan. Threet filed a motion in the divorce case claiming she was entitled to half of Hollandquest's disability benefits. The district court agreed, based on the language of the NFL pension plans and some qualified domestic relations orders, again referred to as quadros, the parties had executed, giving Threet access to Hollandquest's benefits. Hollandquest appeals from that judgment in district court. A couple of issues raised in this case. Number one, are the quadros void because the divorce decree's division of property was extinguished? And issue number two, did the district court have the authority to enter the quadros regarding the disability benefits under the divorce decree's division of property? So with that explanation, who do we have here for the appellant, Mr. Hollandquest?
Joseph Booth for appellant along with Gina Haslett.
And, all right. And Mr. Nelson again, this time for, is it Threet, Ms. Threet?
Yes.
Okay. And Mr. Booth, do you wish to reserve any time for rebuttal?
5 minutes, please.
All right.
I might comment that 4 out of 6 council today have been wearing bow ties, and I heartily approve.
And we promise not to make fun of those who are dressed funny.
Thank you, Council.
I just wish I'd gotten the email, but
Yeah.
apparently.
I was present during the oral arguments that occurred earlier, and I'm sure that some of the same issues are going to prop back up, and I'm prepared to comment on a few of those. In this case, we have a situation in which there was a provision to allow for the division of this present asset, a set of retirement assets that had been earned by Mr. Hollandquest. Exhibit 7 is one of the best places to find his date of retirement, which was 1998. They divorced some years later. Then, more than 5 years afterwards, is the next event. At issue here for the dormancy statute is that after the 5 years have lapsed, but not 7, there was no reviver action or no petition for reviver, nor in the contents of the request for the issuance of a quadro did they offer a verified or affidavit to revive. So without that, there was the judgments that were issued in greater than 5 years after the conveyance of that right in the divorce decree. We have a void judgment.
Was any of that argued in district court? Was that even on the radar screen?
No. It was not on the radar
Why
screen
should we
at.
consider it now?
It's a subject matter jurisdiction question on whether or not the court has jurisdiction to enforce a particular order. If we go to the Associated Wholesale Grocers case, it talks about how these dormancy and reviver statutes are strictly construed, and they deal with the jurisdiction the court has over an individual's property. And
So you
that's
don't think this is an issue that can be waived?
No. The only form of waiver that I know of would be if parties voluntarily consented jointly to the waiver, as was argued earlier in the earlier case this morning.
Mr. Booth, I've got a fact question that I want you to clarify for me. As I understand it, after his retirement, it's when he becomes eligible for these disability payments. He becomes disabled or he becomes eligible. Is there a difference there? This is all post-divorce, correct? Was he retired at the time of the divorce?
Yes, 1998.
All right. And then,
He had ceased playing.
so he was not eligible for these, he was eligible for a pension, whatever that is.
Right.
But these disability payments came well after the divorce,
Yes.
and that's when he became disabled, or
Yes.
was it a part of an agreement with the NFL Players Association that now these players will get these benefits? In other words, he got something as a result of a contract action from the union that all happened after the divorce. That's what I didn't understand.
I'm trying to make sure I understand your question. What occurred,
Well,
I can go from the facts of what occurred.
If it's something that he got well after the divorce, the district court didn't divide it. Couldn't divide it, because the district court at the time could only divide marital property
Correct.
that it had. So if he got this later, it wouldn't be subject to division at all, would it?
And that was argued at the trial that's under appeal right now, that these rights accrued after the divorce, and that the specific provision, if there was any limit and any possibility that these disability rights could have been construed under this provision that the quadro relates to, it was restricted to those rights which were existent at the time of the divorce. And that language at the time of the divorce makes a lot of sense, because we are not dealing with anyone who's working continuously forward in time, and so we're not trying to figure out whether there's a coverture factor involved for post-divorce activity. There is no comment about a coverture factor or any right from pre-marriage. I don't know how long he played. I know when he stopped, 1998.
So I guess to answer my question, it's simply how we interpret the separation agreement, because it was basically 50-50.
It was basically 50-50 of retirement benefits, and all described as retirement benefits. 401K, 401K annuity. Well, I don't want to fall down a slippery slope on what that package is, because that is in effect something of the argument on the second issue. The disbursement of rights within that first quadro issue, he got 50, she got 50, was for the retirement rights, whether they arose out of a 401K or 403B type program annuity. It was a 401K annuity or pensions for retirement that were existent at the time. I'm paraphrasing, I could look it up real quick.
My question, I guess, getting back to your dormancy and the extinguishment of a judgment, parties can always enforce their contracts, can't they? And if their separation agreement said, look, 50-50 is 50-50, and I'm enforcing my contract right.
Parties encouraged the court and anticipated in their separation agreement to inure this to a judgment, and the rules of the judgment itself would apply. And those have been upheld, and the Smith case is an example of that. I want to speak to this issue of quadros somehow being in stasis or not effective until you actually start receiving checks. A quadro is, for the most part, of course, marriage of Cray speaks a lot to quadros, both lower and upper marriage of Cray. But a quadro is a conveyance of whatever rights you have at the time. And when we conduct trials in family law cases, we sometimes come to a present value of a defined benefit plan and then trade that off for something else. So it is a present valued benefit. And as different from the Plank case that you raised in arguments earlier, Your Honor, that case, the Plank case, gave husband a contractual right to establish a lien that would enact later in time, 2 years later. He had his lien against the property that didn't start to accrue interest and didn't start to be effective until a couple of years later. So in the Plank case, they are arranging to convey a future interest in that agreement. In a quadro, whether or not you're talking about a defined benefit plan or a defined pension plan, you're talking about conveying the value of the present interest. And you can convey, if you own a contract for a future interest, you can convey whatever that future interest is to another person. And that is one step different in property and logic than the idea of conveying a future interest sometime later. The Plank case granted this person a judgment that would inure later. Therefore, the duration of when the judgment would become executable is misplaced in time. This quadro and this separation agreement intended by its very language, and it had all the standard bucket of language to separate all the rights of the marriage, Kurtzer, dowry, etc., intended to divide those property rights at present. The only thing that was reserved there was to get the ministerial act, as Smith calls it, to execute that in a separate document. There was a question in the previous arguments about whether or not you do that contemporaneously or not. The law is this, basically. If you're articulate in your separation agreement, and it would qualify under the 401k to the plan administrator's satisfaction, that domestic relations order, which is what a separation agreement is, could be qualified under the plan to distribute those acts. The custom and the tradition in family law is to separate it out and create a separate document because there is a regime and a simplicity to that. It fits within the bureaucratic process of having plan administrators resolve it. And the structure of a qualified domestic relations affidavit is done in a way as to convey all those present rights and to instruct the plan administrator on what to do in the cases of death, in the case of either party, what to do in cases of later challenges, because by filing your domestic relations order with the plan administrator, it becoming qualified as a plan, that has latched in the rights of the alternate payee, and they don't have that right until they've done that. So if wife number 2 comes along in a scenario and receives a portion of the retirement, her rights, if it may be considered superior to the first set of rights if that quadro hadn't been filed. It's absolutely vital to get the quadros filed in a timely manner because it is a conveyance of present rights.
Well, if we assume that in this case, we've got our NFL player, he's healthy, everything's fine, he's just left the league, and he gets divorced, and he says, assuming that you get 50% of my NFL retirement and my NFL disability in case I'm ever disabled, what is the present value of those disability rights as of the date of the settlement agreement?
You'd have a number of answers, but what we do in the tradition of family law is we guess at when the participant would begin to receive those benefits. Often it's a matter of contract. We say it's 65 or 67 years old, and then we conduct a present value analysis based upon the guess of how long they're going to live. There may or may not be survivor benefits that the spouse has already received. In this case, they've dealt with that under just the pension portion. But that present value would be what you would do to create a value if you were not going to convey it. So you have, and we usually use experts to do this, but you have a present valuation of what that is. In this interesting case.
I was just going to say, in this case, though, this fella applied for total permanent disability, was denied, and this would have been back in 2011, which is 6 years after the divorce. Mm-hmm. And then ultimately, he gets total and permanent disability in 2013, which is 8 years after the divorce. And it just seems to me that how can we require the other spouse to say, I should have filed that quadro the day after the settlement agreement? She had no idea that this guy, neither did he, that he was going to become totally and permanently disabled.
Well, the answer is simple. When you have a judgment, you have 5 years to act on it or to file a reviver.
But you can toll it. How could she have I mean, we have language in the Supreme Court and in the dissent by Chief Judge Green in that Americold case, which says that if the judgment is impossible to collect, it is tolled, and the dormancy is not going to take place. how can you collect on a disability which hasn't even happened yet?
My answer is what you're collecting on when you file a qualified domestic relations order is exactly the same contractual rights, whatever proportion you get, that the participant had. That's what you're collecting. That is what the right is. This is a different quantum than what a money judgment would be, because we're not collecting money. We're collecting contractual rights. And it would be, and that could be true in any other species of property. You could be getting a trademark. You could be getting anything else that inures to a judgment as though you receive that piece of property. But what you're receiving when you receive the right in the separation agreement and the clearance to go ahead and do the follow-up ministerial documents are those present rights. And the reason why you have to follow things like our dormancy statute and execute that quadro right away is because those rights could be lost, changed, or mitigated by circumstances that occur between those two acts of judgment and the effort to collect. And in a qualified domestic relations order circumstance, you need to get that thing on file as soon as you can, because you don't know when people are going to retire, you don't know when people are going to die. And one of the reasons why you may have chosen to receive a portion of a future interest instead of its present value is that you are hedging your bets and it may be worth more. Ms. Treat may have well thought that under this set of terms, Mr. Hollenquist could have gone until whatever that contract says for retirement as aged out. For most of us, like working in other areas, 65 or 67 years old. But she may have well thought that he would apply for and be eligible for retirement under some other provision that would have come earlier. One of the other arguments that comes up later in the second issue, whether or not this judgment is void or not, has to do with the fact that he is indeed retired by some quantum, I don't remember the proportion, and disabled by another quantum, and that those two are different. The disability proportion of that is a different conveyance of property for a different purpose under the Boutreau analysis and those that follow, that wasn't contemplated in the original separation agreement as part of the conveyance of the retirement rights.
But we're not dealing with the agreement here. We're having to deal with the judgment of the court, which is supposed to be a reflection of the separation agreement. I understand that. But you seem to be arguing then that this division somehow affected a potential future interest in a disability payment. And I just don't see how you get that. I mean, the division of the assets, of the marital assets, said nothing about a potential future disability payment from the NFL, did it?
No.
It said retirement. I'm with you there, but it didn't say anything about disability.
Correct.
And I guess your argument is it's because it's all the same bundle, it applied to it.
No, our argument is exactly the opposite. Our argument it sounds like you're expressing my argument, and that is that the disability is a different asset. They were bundled together by this administrative entity that handled the conveyance of rights later in time, some years later in the divorce, but the retirement and the qualified domestic relations order, the court only had the scope of authority ever to grant a portion of the retirement, and then because of the dormancy issue, lost that jurisdiction too. The issue with the disability has to do with my second issue, and that is it was not a marital asset, and it's not termed as marital asset under our law, and it was not dealt with under that provision of the agreement that would allow her to get any of his disabilities simply from what is written in there in that conveyance of property in that section of the parties' agreement, which
You're moving into your rebuttal time, I might add, so.
I'll pause there.
May it please the court again, Ronald W. Nelson on behalf of Len Treat. There are a number of misfires or missing the target arguments by appellant in this case. First of all, Chief Judge Malone, you talked about the dormancy and expiration That was not addressed at trial, and while it's a subject matter issue, as the Supreme Court has talked about, another thing that hasn't been talked about in the brief of this case and until the argument today is that no motion for revival was filed. The argument of appellant in the appellant's brief is he didn't do anything within 5 years, and so it's expired. But that's not the law. The law is that a judgment goes dormant after 5 years, and there is essentially a grace period of an additional 2 years. During that 2 years in this case, Len Threed filed a motion for execution on the previous judgment, asking that the court order Mr. Hollenquist to execute a quadro in this case to allow what the settlement agreement and original judgment provided for. The court issued that order, and within it said if there is any need for any changes, modifications to this order, I'm reserving jurisdiction. So we're back to the reserved jurisdiction there.
And those orders, those quadros that were issued in 2011, nobody appealed. Our NFL player guy did not appeal those.
That is correct.
So we have no jurisdiction to right any wrong that may have occurred back then by the district court judge.
That is correct. And within those orders, it specifically referred to the two portions of that plan as defined by the NFL, which were the retirement portion and the disability portion. It's important to note that, getting into the second issue a little bit, while the appellant argues that disability is a completely different animal than retirement, which is true under the cases cited by the appellant, those are Social Security cases, military disability cases, and VA disability cases, which by federal statute are not defined as retirement, but are defined as separate issues.
Mr. Nelson, let me ask you this. At the time that these parties were divorced, was this man entitled to any disability payments? Was he disabled, and was he entitled to any disability payments?
Judge O'Grady addressed that issue and found...
I'm asking you, was he?
He was entitled to it. The condition of him proving his disability had not yet occurred.
He had a potential,
Correct.
but he hadn't even applied at the time of the
That is
divorce
correct.
for disability. And he was denied disability payments years later.
That is correct.
And then with the passage of time and probably better lawyering, he got disability payments. Is that correct?
Or a coming to fruition of
The disability.
disability.
So I just don't understand. I guess I'm jumping to the second issue. If the court couldn't divide it, if it wasn't a marital asset, then I don't care about all of the dormant issues and all of that. If it's not a marital asset, the divorce court isn't dividing it unless the parties have agreed to it. Now, if the separation agreement calls for it, that's a different story because that's a contract. The parties are free to contract that. And even potential disability payments. Is that what your argument is?
Well, you're speaking, I believe, of a factual issue that was addressed by Judge O'Grady. Specifically, in his decision on the order denying the motion for new hearing, he said, on page 5 of that particular order, the entire retirement system was divided equally. The disability plan existed at the time of the divorce. The fact that Mr. Hollenquist did not value the disability benefit or did not believe it would ever have any value does not change the agreement that he made or the fact that the plan existed. Again, the fact that he was not receiving payments from it is a different issue altogether. What was provided here by these parties' agreement was that the disability would be divided 50-50, that it was part of the retirement plan, and therefore it's included in the orders, and when the NFL required that the order be split out, that was done.
This disability quadro that we're we're having this litigation over. This came to being because the NFL notified the ex-wife that we need some additional paperwork, as I understand it.
Well, and not even additional paperwork, but that they would not accept the original QDRO because it included both portions. And they administratively wanted it separated out to two files.
So an argument could be made that in 2011, this situation was resolved. The court ruled you get disability payments as well as the retirement payments. Here's your quadros, and we just got a quadro sent up to the NFL, and the NFL says, we don't like the language, send it back, and then he wouldn't sign, we couldn't file, so we have this litigation here. Is that?
That is correct, and there's.
So really, this quadro is supplemental to, it's the follow-up to a quadro, the three quadros that were signed and filed in 2011.
Stated another way, it is corrective of.
But if the first one isn't effective, it's a nullity. It isn't, this one is effective, this is the real deal. The first one, if it's a nullity, why appeal it? This is the one that really divides it, so this is appealable, is it not?
Well, the first one was,
If the NFL isn't going to follow it, then it's ineffective. It has to be qualified, right? And it's qualified by the plan. If they don't agree with it, then it's not qualified, it's a nullity. So the only qualified domestic relations order is this one, which is subject to this appeal.
well, as not qualified, it is not a nullity, it is not qualified.
Well, what good is it? If they aren't going to give you the money, you can look at it, you can put it up on your wall, but it's not going to do you any good.
And so that is why the reserved jurisdiction provides that it can be changed as required by or as desired by.
Now it's qualified because the NFL has agreed to it, the people who run the plan. And that's appealable.
Kansas law doesn't look to whether it's qualified or not on appealability. Kansas law looks at when is the judgment or order final.
Why would you appeal a 2011 quadro that is ineffective, that doesn't divide a dime, doesn't send money out to anybody? Now, you might want to appeal an order that divides assets, but that doesn't divide anything because you aren't getting anything.
Except Kansas statutes don't condition the appeal on if it's approved. Kansas.
Well, what's
statute-
appealable in this case? Are you saying that the
Well-
last quadro isn't appealable?
In 2011, that order was appealable not more than 30 days after the date it was entered.
I understand that, but it didn't divide anything, it didn't do anything, it's just sitting there. The 2013 is the one that actually divides the money, right?
Well, I would disagree with that in that, yes.
Well, are there
it
people getting the
divided.
money now? They weren't getting it before.
I understand that, but the order divides it, the order makes the division. It's that the administrator wanted something different.
Well, so now it's effective. That's the order that's really binding on everybody, not this prior one. That's academic.
And I would disagree, the previous order was effective against these parties.
Well, they didn't get any money.
But that's not what defines a judgment.
I see.
I mean, they didn't get money not because the judgment was defective, it's because the NFL didn't like the form. And we're not, this appeal has nothing to do with whether or not the NFL was right in rejecting the form.
Unless there's anything further.
With regard to this idea of whether or not we have any jurisdiction over the first set of quadros in 2011, anytime the court lacks subject matter jurisdiction, it can be raised at any time. And if those original orders were void, with the same logic of what do you need to appeal if it doesn't distribute anything, it was void in the first place, where do you go? Those orders were void under this logic of dormancy and reviver that was said. It was argued that we did not raise the issue of reviver. It is literally part of the first issue in the text, and we raised it in our brief in talking about the reviver and the failure to revive in the statute. But when we go to divide these plans and we have that issue, what we've gotten to talking about are effectively three things that are spoken of within our two issues. One has to do with the subject matter jurisdiction of the court and when and where it was seized or not seized. The next has to do with a stream of retirement income, which is a retirement policy and clearly expressed in 1G and 2E of the parties' agreements, Record on Appeal pages 20 and 21 of Volume 1. And that's where that operative language rests for the quadro that this quadro is arising out of. And that language deals solely with pension issues and does not deal with anything relating to disability. While it was argued that our courts review disability as not part of a retirement asset or as part of a retirement asset in toto, I believe the Utro case used those cases that arose out of other federal rights, federal background of cases, and looked to the intention of the payor and the analysis process in order to determine whether or not this was a divestiture of a right earned by retirement, the purpose for which is to pay what we usually think of in retirement, versus the replacement of lost income because of disability. And in this case, we know that under Exhibit 7 in the Record on Appeal, that Mr. Hollenquist, after his second attempt to obtain disability, received disability because he was within 14 years of service of the NFL, but it was not necessarily arising out of his service of NFL. And so that type A retirement that they speak of in that Exhibit 7 has to do with a replacement of lost income that inured as a right because he suffered a disability within 14 years after leaving the NFL, but not necessarily from the NFL. And we know that that right had begun to occur through the application process. One of the first conditions is that you have to have an application later in time between these two qualified domestic relations orders that we're talking about. I have no further comments.
All right, thank you, counsel, very much for your briefs and your arguments. We'll get a decision out to you and your clients just as soon as we can. That completes this morning's hearings. I might add, for those of you in the audience, although we normally don't do this, but we'd like to take this opportunity today. If any of you have any questions about any of the cases that you saw this morning, we certainly can't comment on the substance of any of these cases or how we're going to decide any particular issues, but we may be able to answer your questions about the procedure of the cases or just general questions about how our court, the Kansas Court of Appeals, works and what our job entails. We'd be happy to take a stab at any questions that any of you might have. Yes, sir.
Ron Nelson.
Apparently, he's taking
Give him
a
your
record
card.
here. Any questions about any of the hearings we had this morning? We'd be happy to take a stab at it.
I'm sure Professor Nadelman has a question for the panel. Yes.
I do have a question for you, and that is, in the event, this is a hypothetical question, which professors get to do. In the event that you were to find that giving an instruction at the beginning of a trial, as if it did, violated the constitutional rights of the defendant, the instruction that, basically a dynamite instruction at the beginning that you're wasting taxpayers' dollars, would this have an effect as it does when the Supreme Court has a decision that convictions would have to be reviewed from that jurisdiction? Or would it open up the possibility of defendants raising convictions, attacking their convictions?
I'm not exactly sure. Are you asking about what the remedy would be?
What would be the potential consequences of finding that you know, you're looking at an individual case, so, you know, you address individual controversies come before the court. In this particular case, one of the grounds of appeal is that the court gave an oral instruction at the beginning of the case saying that taxpayer, you know, you need to reach a verdict, it's your duty, taxpayer dollars at risk. And that, as was indicated by some of the panel's questions, borders on the charging prohibition at the end, where you have the jury come in and say, we can't reach a verdict, and the judge sends a note, dynamite, you've got to try to reach a verdict, but you can't. So my question is, if you could elucidate for the people here, what would be the consequences of finding that, in fact, that is chargeable error in a case? And would it open up a possibility of other persons who've been convicted in that particular jurisdiction of saying, me too, and then seeking habeas corpus?
Well, the consequences in the particular case would be that we would reverse the defendant's convictions and we would remand the case for a new trial. In other words, you just have to start the whole trial over again. Now, as far as consequences to other cases, it really wouldn't have any direct bearing on anybody else's cases that have already become final and are over with. Now, in future cases, of course, though, they can always cite to our case as precedent and say, look, here's how the Kansas Court of Appeals ruled in this case. They ruled this was reversible error in this case, therefore it should be reversible error in my case. So in any ruling we make has that precedential value. I hope I answered your question.
You did, so you would not anticipate then other defendants raising the argument now?
That are in like maybe prison serving a sentence. No, I really don't think it would open the floodgates to any type of thing like that. Any other questions?
I would just like for you to comment for the audience on about how many cases are appealed every year, how many you actually have oral arguments on, and how many are disposed of just through written arguments.
All right, well, in general, our court usually handles about 1,800 appeals every year. That's how many cases generally are filed in our court. Of that amount, about 1,400 of those are disposed of by formal written decision. In other words, like you've heard today. But of the 1,400, though, that are disposed of formally, I would say maybe about 1/3 of those have oral argument like we had today, and the other 2/3 are what we call summary calendar. In other words, the cases are handled in just the same way. We read the briefs, we consult, we deliberate on the cases the same way. They just don't have oral argument to those. Only about 1/3 of our cases actually have oral argument. Yes, Anita?
In this whole process of submitting briefs and then having this oral argument, how much impact does the oral arguments have?
You two want to take a stab at that?
That's a very good question. I appreciate having oral arguments on cases because it's the one time where lawyers and judges can ethically talk about a particular case. And you can read something in a brief, and you can read the record on appeal. But sometimes you just have to be able to understand how the facts get where they are in the record by talking it over with counsel. And now sometimes it doesn't make any difference, the oral argument. Somebody's going to lose because they just have a losing argument. But sometimes in oral arguments, it makes a big difference. And I can remember a particular case where I went into the hearing and thinking, wow, this is just slam dunk. But then, during oral argument, in response to a question, counsel said something, and it's like everything came into focus. Ah, that's what that means. And it certainly changed my view of the case like that. So I think it's very important.
Boozer, do you have anything to add?
No. But anyone have any questions about the legal profession? I'm afraid due to some of the subject matter that you heard this morning, probably there are some of you who came into this room wanting to be lawyers and are going to go out and are going to look into selling life insurance. But, you know, the legal profession is a wonderful profession, and for my 30 seconds, let me just say that the neat thing about the law is you're always learning stuff. And if you're interested in what's going on in the world, and if you have an interest in learning stuff throughout your life, the legal career is a neat career. Some of us, you know, are kind of interested in maybe prosecuting criminals. Others of us would like to defend criminals. Some people only want to do adoptions. Other people love real estate. The really smart people get into trademark and intellectual property.
Absolutely.
And if you do that, you'll be very wealthy and live happily ever after. But it's a tough gig. So the neat thing about the law is that you can. My son is a lawyer, and I always told him, you know, think all the great things you can do with your life. You can change people's lives and everything. He says, Dad, I just want to make money. And so that's what he has some issues. But that's what he's doing with his life. He's making money with a law degree. So I just want to encourage you to, you know, to consider a legal career, especially shout out to all of our women members here, because in the old days, which is when I went to law school, we had very few women going to law school. Today, it's at least 50%, and law firms and big law firms are making accommodations to women so that women can have families and things like that, accommodations which in the old days just didn't happen and was a barrier to women. So just because you're a woman, don't be afraid that you're not going to be able to get a good job in a big law firm because there is more equality now than there was before.
Any questions just about the legal profession? Going to law school, whatever.
Question back there.
Oh, I'm sorry.
I don't know if you've already answered it, I don't know. But what would be like the average salary for a judge be?
Not as much as you think.
Yeah.
It could be a lot more.
That's right.
As a general rule.
That's not enough.
Right.
It's not about the money.
We're in the public sector, and that generally is not as financially rewarding as the private sector.
Is that set by law?
Yes.
So if you Google it, you can look up and find the answer.
Question over here, I saw not here.
So why haven't you gone to the private sector yet?
Well, I spent my first 15 years practicing law, and then I became a trial judge down in Sedgwick County for another 12 years, and then got appointed to the Kansas Court of Appeals. That's been for about the last 12 years. So I've seen the broad spectrum, and both of these judges have experience in private practice as well before they became judges.
You've got a 5-year waiting period before you can become a judge anyway. So you have that on the minimum.
So why not stay at the private sector if you just know?
Well, some of us, I'd like to be a judge. I enjoy doing it. And, you know, lawyers practice law. I get to make law.
We're not all like Judge Boozer's son.
That's right.
Well, thank you very much for coming today. We certainly enjoyed having our hearings before you.